Hello and welcome to today's webinar, Subsale Agreements on behalf of Legal Futures, presented by me, Peter Dollar. I'm a full-time freelance lecturer, trainer and writer, but I was in practice for 25 years and I did deal with quite a lot of subsale agreements in my time. So, as I'm sure you all know, subsales can be tricky. And of course, they do involve additional risks for the parties, particularly for the ultimate buyer, but also for the seller. And the whole idea of today's webinar is to clarify the main issues. So I'm going to look at, first of all, what exactly is a subsale. Then I'm going to look at issues for the seller, issues for the intermediate buyer, the first buyer, and issues for the ultimate buyer, the sub-buyer. Then I'm going to look at some drafting points for the subsale contract, some drafting points for the transfer or transfers if there's two of them, completion issues, tax issues, and finally, lessons from the cases. So, let's start by answering the question, what is a subsale? Well, strictly speaking, a subsale is where the seller contracts to sell land to a buyer, and before completion of that sale and purchase, the buyer contracts to sell the land to a third party. And completion of both of those contracts then takes place more or less simultaneously. Now, completion may take place by using two separate transfers, one from the seller to the intermediate buyer, the other from the intermediate buyer to the ultimate buyer. Or it may take place using a direct transfer from the seller to the ultimate sub-buyer. And of